with the Honorable Mayor presiding is now in session. Please be seated.
Good morning. I hope everyone's having a great Tuesday. Welcome to the First District Court of Appeals. Today, we're doing an offsite at the University of Cincinnati College of Law, my alma mater. So we're very thrilled and happy to be here. We do have 3 cases on the docket this morning. And I'm going to be calling them individually, so I'll only be calling one case right now, which is the first case that is going to be arguing this morning. That is case number C240404, State of Ohio versus Sean Curry. If the attorneys can please identify themselves in their readiness to proceed. Good to see you, Josh. It's been a while. Good to see you. It's been a week. All righty. Joshua, whenever you're ready.
May it please the court, I'd like to reserve 3 minutes for rebuttal.
Okay.
This case is about the police violating the Fourth Amendment and then retroactively justifying it with an affidavit that was reckless in its disregard for the truth. The claimed exceptions to the Fourth Amendment by the state were not supported by fact in this case. I'll start with the protective sweep. Maryland v. Buey requires articulable facts suggesting a hidden person posing danger. That did not exist here. There was no evidence that any adjoining area to the place of arrest harbored someone who could launch an attack on the officers. Both suspects, Mr. Curry and Ms. Brooks, were in custody before the so-called protective sweep took place.
Ask you about that. How were the officers to know that there was no one else in the apartment but the 2 people that were arrested?
Well, they don't know, but they determined that they had secured the area and left. So our position is essentially it was over and no longer a need to know.
When they made that determination, though, they know that there was a closed door with a dog behind the closed door.
Correct.
So how could they assume that that room was clear?
I don't know how they did, but they did.
Well, it seems to me that the officer that actually entered the room was operating under the assumption that it had not been cleared.
It may or may not be the case, but ultimately they were no longer in danger is the real issue at hand there, that there was no reason to go in there to seek danger rather than secure the area and get their warrant.
Now, Sharp seems to be a case that's relied on with regard to this issue. And in that case, the police had come to the home on 2 occasions. The first time they were seeking the person that they were looking to arrest. And then the second time they procured the arrest. And in the first time they were able to speak to the other occupant of the home. In this case, there was only one time, and when there's no evidence on the record that the police knew anything beyond what transpired on the date in question, right? So how would you say that this still would be a violative protective sweep and unconstitutional warrantless search?
Because of the limited information essentially compared to Sharp, is that?
Well, yeah, because in Sharp, they knew more about the residents, the occupants, what it is that they were walking into. Here, they really don't know very much except what's transpiring at the moment.
It boils down to the reasonable belief or the articulable facts that someone's in there, the danger that's at play here. So.
And this is a very low threshold. This is like the akin to a Terry frisk. In other words, it's not probable cause.
Correct. I would argue it lies somewhere in between.
Don't you think as a matter of standard operating procedure that it's prudent to sweep the entire premises when you don't know the occupants of the entire premises?
It might be prudent, but it's not what the law allows for. The ultimate question is articulable suspicion that there is a harm behind that door, which is really the question here. There was no indication whatsoever there were people there, so the essence of the issue is that it's not carte blanche to enter any room to make sure there's no harm when you've removed the people you're looking for and have so-called secured the area and exited.
So that's your only issue, just so I'm understanding. The initial protective sweep was fine, right? You don't take issue with that. You're taking issue with going into the bedroom where the dog was.
Yes,
Okay. And so what you're saying is that the officers, once they said clear and they left to go get a warrant, that the going into that bedroom without a warrant was the problem.
that and whatever must have occurred to allegedly see the items on the kitchen counter.
Okay, but that's a separate thing from the protective sweep, right? So because the only thing found in that bedroom was, I mean, it was a gun,
Right,
but they had already found drugs before during the protective sweep that you're saying is okay.
yes, yeah.
Okay.
Joshua, I have a question for you. It's kind of more of a procedural question, and it bleeds over into what is our standard of review on this particular matter that you're arguing. In my review of the motion that was filed, that motion seemed to be completely not only centered, but all encompassing with regard to the warrant itself, right? It was asking for Frank's hearing on the warrant, on the veracity of the statements that were within the warrant. It didn't go beyond that until the closing argument, when there was a supplemental closing, which raised the issue that you're raising here on the search. On the warrant, the defense would have the burden of proof. So when did that burden of proof shift to the state on the search?
I think the court's finding, essentially, when it was shown that it was questionable, or frankly, a reckless disregard for the truth, that anything was in plain view. That aspect of the affidavit for the warrant should have been removed from the warrant for analyzing its validity. So essentially, once that threshold had been met, it should have been on the state to show that the statements were not at least recklessly disregarding the truth.
Okay.
Shall we move on or?
Yeah,
Okay.
so just so you know, you have 6 minutes,
Okay.
all right?
Part of the problem that we end up running into in this case is that the body cameras get turned off after the scene is secured. And that a number of still photos were shown that, at least in those photos from the body camera, it is not immediately apparent that there are any drugs in plain view or any other contraband. I know that there was discussion of a syringe, but that was not relied on by the police. I believe it's a red herring in this case.
So is the implication here, is what you're trying to imply, is that the police turned off their body cams and then rummaged through the apartment and then pulled out the drugs and set them on the counter and then said, oh, they're in plain view? I mean, is that the
Yes,
implication?
That is, yes.
And so the trial judge heard the testimony from the officer who said, no, that's not what I did. The drugs were in plain view. You couldn't see them from the body cam. And the judge seemed to believe that testimony, right? So what do we do with that as an appellate court? There was a credibility finding below.
There's two answers to that. First, the court also found that it was questionable that a question had been raised about whether those items were in plain view. And to say that he still believes the officer, the trial court still believed that the items were in plain view, is just because there's deference to the trial court for a credibility determination when there is clear evidence that the statements by the officer were not credible. This court should reverse based on that.
What's the clear evidence that his testimony was not credible?
It's what's not there. No one points out the drugs on the camera. The pictures we do have, despite any claims that they don't show every angle an officer could be looking at, they don't show any drugs. They don't show anything. In fact, they show the bag kind of against the wall, which is a strong indication that the drugs would have been tucked under the bag. The scale they thought they saw had camera lenses on it. It was a cell phone. But in terms of credibility, again, I think it's that they don't call out the drugs. And on top of that, if you're doing a protective sweep, you're looking for people for a harm. There's no person hiding behind this bag. There's nobody on the countertop. And one of the officers even testified.
Well, plain view would apply in a protective sweep, would it not?
Sure, if things are in plain view.
And I understand your argument. What you're saying is if they had seen the drugs in
They had the
plain
right to
view
be
during the
where they are.
protective sweep, there would have been discussion on the camera to such.
Yes. And I was going to say, but one of the officers testified specifically that they were looking for evidence, not people. Officer Wolf on transcript page 156 admitted that they were not just doing a protective sweep. They were looking for evidence.
If the officer had not testified to that, I mean, do we still have the same kind of case? Is this testimony what puts us over the edge?
I think it is testimony that it's evidence that adds to it. I don't think it changes the case in the sense that there is still contradictory evidence to their testimony here.
But what you're really asking us to do is to find that the officer's testimony, despite the judge's finding that it was credible, you're asking us to find that it was not credible.
Yes,
Or even that it was altogether false or fabricated.
it was at least recklessly untrue. I'm not sure. There's a
Well, it seems like that's even more. Like the implication of the pictures of the body worn camera might be contrary based on looking at the pictures, but seems like it's a lot different than they flat out made this up or lied in a warrant. It seems like that's quite a stretch for an officer to say, I'm just going to lie in a warrant that I'm going to present to a neutral magistrate in order to get a warrant.
I think that one can think they're doing the right thing and not think they're lying, but ultimately be telling something that's not true. And that's ultimately what happened here is we even saw that the officer, Wolf, I think, the one that, maybe not Wolf, Dotson, the one that wrote the affidavit.
Dotson was the one who entered the room, and Wolf, I think, wrote the warrant. But he said that I entered the bedroom, and that seems like it was recovered in testimony. He said that was just a mistake.
Sure. They didn't see drugs and then said they saw them in plain view. That's kind of the problem we deal with in these Fourth Amendment cases is it's very easy to explain away.
But as to that statement in regards to entering the room, it was because Dotson had told him that he had entered the room and seen a gun.
He wrote, Affiant saw a gun on the bed. I mean, he knows who he is. They had an hour and a half or plus that to write this warrant. It draws into question the validity of that. It creates a time frame where they're turning off their cameras, claiming that it's because they won't interact with the public. So a strong indication they didn't think there was anyone inside to worry about. and gives them carte blanche, whether they meant to or not, to do whatever they want and then claim that it was justified after the fact. And that's what happened here.
It seems to me, Joshua, that you would need for us to agree on both matters because the only way to get to the bedroom is through the protective sweep.
If the warrant was valid, then I suppose that might get you in there as well. But that's why we have to deal with both issues
Yeah,
here.
yeah. Because otherwise, then you're looking at a potential inevitably discover with regard to,
It
even if
would
we
have been,
agree with
but-
regard to the drugs.
Yes, but we also argue that the state waived that by not raising it below. In fact, even trial counsel in their initial motion brought it up, and the state still didn't bring it up in the hearing. If there are no further questions, I'll reserve the remainder of my time.
All righty. Thank you.
Morning, Your Honors.
Good morning.
I guess briefly, I want to first address this notion of the Franks hearing and how the trial court actually treated this motion. And they basically took Mr. Curry's defense counsel at their word and treated it strictly as it was framed, which was as a Franks hearing. Basically, they had to show by a preponderance of the evidence that the not the testimony, but what was submitted in the affidavit either had a knowing disregard for the truth or was perjury, and there really was very little evidence of that. So in that regard, strictly treating this as a Franks motion, this is an easy affirmance. It should be affirmed. There's no evidence really that's been submitted that Officer Wolf in his affidavit, knowingly lied to Judge Greenberg about what had taken place in the apartment to that point, what they had observed.
Well, I want you to speak to one of, and I apologize, I keep calling you Joshua. I hope you don't mind, Attorney Thompson's arguments. And that is that had they seen the drugs in plain view during the protective sweep, that something would have been articulated on the body-worn camera.
Well,
video.
so I think what's important to note here is that the officers made 3 entries into the apartment. They made the first entry under exigent circumstances to go retrieve Miss Bright and Mr. Curry out of the apartment after Mr. Curry was firing the gun off outside. That was clearly permissible. I don't think Mr. Thompson or Mr. Curry disputes that at all. So that was fine. Then you have the second protective sweep, and it's not clear what the impetus for that was. There was conflicting testimony from Officer Wolf.
Because on the first, Officer Wolf is not involved. He comes into the second, right?
Right. And he says basically something to the effect at one point that it was for looking for evidence of guns, basically to the crime that had taken place outside of the apartment. But at another point, he says it's to make sure that there aren't other people in the apartment. Notably, it's a small apartment. They don't go into that bedroom at that point. Then you obviously have the third entry, which is Officer Dotson going in to retrieve the gun or the dog and finding the gun on the bed.
To which there's no video, body-worn camera video with regard to that moment.
Neither the second or the third, Your Honor. I think the first entry into the apartment is the only thing that is covered by the body-worn camera.
So isn't that the problem in this case? We can't test the pictures that we see versus the body-worn camera versus what might have been recorded on a body-worn camera if we actually had.
I would point out to the court that notably Defense Exhibits C, E1, E2, and E3, those are some body-worn camera stills.
So why do we have those and not the actual body-worn camera?
Those were submitted, the body-worn camera is also in evidence.
Okay.
And
From the protective sweep?
from the first entry into the apartment.
So I know the first entry, but the second protective?
Body-worn camera was turned off for that second protective.
That's what I'm saying. That's what the problem is.
Potentially a problem. I mean, basically, the lack of body-worn camera relative to that second protective sweep, you have to rely on the officer's testimony. It's a credibility issue, ultimately, at the end of the day. There was testimony that they were acting in conformance with their internal body-worn camera policies. Shrewdly, as Ms. Deering pointed out in the actual hearing on the motion to suppress, the lack of the body-worn camera, it's not a constitutional thing, it's a procedural thing. It gets to the credibility of the testimony of the officers, but at the end of the day, what's important is that Judge Wagner ultimately found those officers to be credible. And in the in the absence of affirmative evidence to the contrary, I think this court is obligated to accept his credibility determination on that point.
Just as a matter of body worn camera policy and procedure, it sounds like the stills are from the second or the third. No, not the third, but the second sweep.
No, they're from the first, Judge.
Okay, they're
They-
all from the first.
They are all, everything in terms of stills and body worn camera is from the first entry into the apartment.
And I want to clarify this, and this is just a clarification on facts, because it seems as if the testimony muddled this up. You're here saying that all of the body worn camera is prior to the protective sweep. Did I understand that?
I think they characterize both the first and second entries essentially as a protective sweep.
And that's what confused me, because they said, well, we turned it off when the protective sweep was completed. But when I watched the footage, I
Correct.
was like, that is the most unprotected protective sweep I've
Right.
ever seen, because they were just flowing through the apartment
Going in with
to
the
get
guns
to
drawn,
Mr.
ready
Curry,
to-
yeah.
Mr. Curry,
Yeah.
yeah. So I think basically what this may evince is that there's some confusion on CPD's part at certain points what a protective sweep actually is. And actually, I think they also, Officer Dotson characterized his entry into the bedroom, the third entry into the apartment, also as a protective sweep to a
Well,
certain
and
extent.
isn't that what was said in the warrant, basically, is that they entered that bedroom as part of the protective sweep and saw the gun in plain view?
Well, so they're referring to multiple entries into the apartment in that warrant. It was just kind of a fluid situation. So Officer Wolf leaves the scene. He goes back to the station house after, I believe, the second protective sweep to write the warrant based on what they had observed during that. Now, during this time, Officer Dotson is milling about outside the apartment. The nice neighbor approaches him and says, "Oh, yeah, I can take that dog. It's not aggressive or whatever." So they go in to retrieve this dog, and that's the point at which Officer Dotson finds his gun on the bed, lying in plain view. Clearly, that was true. Defendant has not really disputed that at all, that was true. So,
Well,
So-
I'm sorry,
Go ahead.
he does dispute it with regard to the fact that Wolf, as the affiant, said that
Right,
he was the one that
they
saw
they
the.
do dispute
gun.
that. They don't dispute.
So
the-
he's using that to challenge the veracity of the statements.
They don't dispute the critical operative fact, though. There was a gun lying on the bed in plain view. We've got pictures of it. That was submitted into evidence. That clearly happened. Now, obviously, there was a bit of a typographical error, as I would characterize it, and I believe as Officer Wolf and/or Dodson characterized it. There was an explanation for that. Basically, I was in a rush to get this warrant to Judge Greenberg. It was,
It seems like a pretty big mistake to make.
if you read enough of these, Judge, and I don't know how many you did when you were on the bench in common pleas, they're not always, they
But it seems
It's a
to me
lot of
CPD, it is a lot of cut and paste in warrants, but it seems like they are pretty good at preparing a warrant for a judge to review, especially when it's based on something so hot and fresh where they have officers at the scene.
You know, I'm not going to sit here and say that this was the best police work in the world, okay? But I think in terms of whether this was actually, knowing, basically offering perjury to a court, I don't think that the defendant has met that standard. Maybe this was,
You do make a concession in the brief that the protective sweep may have been overly broad.
may have been evincing a misunderstanding on Officer Wolf's part of what a protective sweep actually is. But I think what rehabilitates this ultimately, and I'll point to a couple things in the record. Page 290.
Before you get into your rehabilitation, I just want to understand what your concession is. What are you saying was wrong with the protective sweep?
Depending on which part of Officer Wolf's testimony you believe, there was one point where he said that we went in there to make sure that the apartment was secured. If you believe that, it was a perfectly valid protective sweep, I guess. On the other hand, he testified that we were going in there to look for guns, ammo, evidence of the crime. That's obviously an evidentiary search. That's a problem potentially for
But
the state.
like when he said that, of course, that serves as kind of the basis of their idea that it was an improper protective search, but
I agree with that.
aren't they always looking for things that are in plain view when they're doing a protective sweep?
I mean, I would imagine if they're doing their job right, yeah, in a certain respect they are. I mean, if it's in plain view, it's in plain view. And in this case, there was some testimony that it was, in plain view. And actually there was some of the defendant's own exhibits, C, E1, E2, and E3 tended to show that what appeared to be potentially digital scales were tucked under that bag against the wall. So, you know,
Just so I'm understanding, so they go in, the shots are fired, Mr. Curry runs into the apartment. They go in, they get him and another woman that lives there.
Right.
Then they shut off their body cam. They go back in. They do what they call a protective sweep.
correct.
This is what the one that you're saying may or may not have been proper.
Correct.
Okay. Because the testimony was they were looking for evidence.
And as I'm sure the court's picked up on right now, this is a bit of a muddled record.
Right.
It could have been a little bit cleaner down below. My understanding, based on reading everything, is that it was during that search that they found scales.
Okay. Because then you make an inevitable discovery argument. And that seemed to be focused to the gun,
Correct.
not the drugs.
Correct. And I would like to get into that. And this is what I think kind of saves the denial of the motion from the state here. So I framed, if you want to talk about questionable tactical decisions, why I chose in retrospect to frame this solely as inevitable discovery, I don't know. Ms. Deering below basically said that it was independent probable cause. I believe that's true. I think that's what I was trying to get at here. You have Officer Dotson, he's outside the apartment. You've got the situation with the dog. You've got a couple things going on here. First of all, you've got some officers that think that they're about to execute a valid warrant. So there is a basis for him to go in there and do a protective sweep of that bedroom. That gun's in plain view. That's independent probable cause right there. The other thing, and this is the inevitable discovery argument that I made, is that, you know, you had Mr. Curry, who's going to jail. He's one of the occupants of the apartment. You have Miss Bright. She just assaulted a cop. They're both going for at least a night. Something has to happen with that dog. The cops, in more of a custodial function, have to do something about that dog. They can't just leave a dog in the apartment like that. That's arguably contributing to neglect of companion animals in a certain respect. So they had
That's
to
the
go there.
third, that's the third entry.
Correct.
But
Correct.
the second entry, if that went beyond the scope of a protective sweep and that's when they see the drugs, isn't that a problem then?
In terms of the probable cause relative to those drugs, potentially, but what my argument would
The
be
warrant.
is, right, with the warrant, but you've got Officer Wolf, he's off writing this warrant, and during this time, Officer Dotson goes in, you know, mistakenly believing, perhaps in good faith, bad faith, whatever, that they're about to do this warrant. So he sees this gun lying on the bed. He relates that to Officer Wolf. That's independent probable cause right there.
Okay.
Yeah.
Right. So you're saying
I'm
despite,
saying it's still,
despite that if we.
So
even if you knocked out the stuff about the drugs and the scales and all that, you've still got a gun on the bed. That's weapons under disability relative to Mr. Curry, and it's probable cause that there's criminal activity going on in the apartment.
and then it becomes inevitable discovery.
Well, I framed it as inevitable discovery. You
And
can
so
look
what
at-
about the idea that it's waived because it wasn't raised below?
Well, I don't know if we have to get into that because at the end of the day, it did provide independent probable cause. Why I chose to call it independent or inevitable discovery, you know, I would have to go back and ask myself 5 months ago or whenever I wrote this why I did that. But the greater point is that it's inevitable, or it's independent probable cause relative to this warrant. So even if you excise all the stuff about the drugs, the scales, yada, yada, in the kitchen, you've still got this gun on the bed. That's independent probable
So
cause.
that bedroom, that was not a protective sweep. That was just,
Actually, I believe Officer Dotson did characterize it as a protective
he
sweep.
did, but it was over by then. And then the neighbor said, I'll take the dog. So they went in to get this dog.
Well, the fact of the matter remains that that bedroom, no one had gone in there yet. So if they're thinking that they're going to execute a search warrant, doing a protective sweep, I think under those circumstances would have been appropriate.
So it's like an incomplete, the first sweep was an incomplete protective sweep because
Correct.
they thought the dog was
Correct.
aggressive and they
And as I'm sure you're all aware by now, having been on the bench for a long time, these situations are never, you know, textbook cut and dry law school fact patterns. So it's a bit of a messy situation, but the
I want to
state's
go back to the
position-
hearing itself, to the motion.
What's that?
I want to go back to the hearing itself on
Mhm.
the motion that was filed,
Sure.
and the hearing that was had, because all these arguments are going to be contingent on whether that initial hearing was solely a Frank's hearing. And you did speak to that very quickly at the beginning
Yeah.
of your argument. Can you speak to that a little bit more?
I mean, the way the motion was framed was strictly as a Frank's motion. I know there was some supplemental argument that was unsolicited from the defense in a closing brief relative to the actual constitutionality of that, but that wasn't really explored, you know, that much at the motion hearing. So to the extent that that's at issue, and the court is not buying what I'm selling with regards to the dog, I think an appropriate remedy potentially would be a remand to flesh that out a little bit. So I've got nothing more unless the court's got questions. Thank you.
Thank you.
Um, Addressing what counsel just said, I actually think that this discussion of confusion on a protective sweep is just more indication of saying words that the police know will justify a search.
Well, ultimately, regardless of the arguments today, because the arguments are not part of the record, we're not even a court of record, what was presented testimonially from the officers on this, on the protective sweep, whether it was one or two and all of that.
It, very little to justify anything you'd call a protective sweep, effectively nothing, because they still have to have articulable reasons why there's a danger. They have this place empty. There is no reason to not wait for the warrant.
I think there's a concern. You have two separate issues here. Number one is the Franks issue, saying they lied to get the warrant. And then the other is the warrantless search, or you're arguing on the protective sweep. I think there's a concern, the state has raised this, that this wasn't properly preserved by the defense because the entire initial motion was based on Franks. I know at the end, there was a supplemental brief filed and the defense did raise the issue of the protective sweep. So the question is, was that enough to preserve it?
When you're dealing with these Fourth Amendment issues and you have a warrant, to get to any warrantless exceptions, you have to get past the warrant in the first place. So these facts that are developed at this hearing, essentially, once it's established, this warrant was based on facts that were not, that were reckless with regard to the truth, then we start getting into these plain
But
view.
if the drugs were found during a warrantless search, then that would get rid of the warrant.
Right, that's,
Right, so you would want to challenge the warrantless search. What you contend to be, yeah, it's a warrantless search, and you're going to challenge and say that this went beyond the scope of a proper protective sweep. They allegedly found these drugs in plain view during the protective sweep. They can't rely on them to get the warrant, right?
right.
And so what it seemed like was that the motion was focusing solely on the Franks issue and not really on the protective sweep piece.
Well, that was the title of the motion, but there was significant mention at the beginning about the exclusionary rule.
But I think the judge was trying to parse that to say, to limit it. The judge was trying to limit it to the Franks issue. I mean, I think the judge was trying to say, look, all we have is a Franks issue.
If that's the case, and I have to differ there because I would argue that the Franks issue really wasn't addressed very well, if at all. There was no attempt to review this warrant with this information excised, the information that the court itself said was in question. So
The judge found that he believed the police officer's testimony, and so he didn't think it was a lie.
he couldn't make up his mind, I think.
Okay.
So Attorney Thompson, this is my concern here that I'd like for you to address.
Mhm.
Because it does appear as if the motion was filed as a Franks. There's some clarity that is established by the bench and defense counsel that it is a Franks hearing. And in a Franks hearing, the defense has the burden, right? But on a warrantless search, the state has the burden. So at some point, you were saying that, well, once the evidence started to present itself, that perhaps there was an issue with the search, then that was, and you didn't use this term, fair game. But at that point, how is the state on notice that they now have the burden?
Well, there's not really ever a moment in a motion to suppress where someone says, okay, the burden shifted now.
Well, if you're starting off with the Franks and now you're shifting to something else, it seems to me that something would have to be done, maybe a motion for leave or something would have to be done at that moment.
One, I would request the opportunity for additional briefing on the issue if we need to. Alternatively, remanding the case, undoing the no contest plea and guilty and remanding to look at this further could be another option for further clarification here.
Understood. I appreciate that.
Another issue I did want to address is the bedroom. There's this idea that,
Mr.
need-
Thompson, I'll give you
okay,
a minute. How's that?
just short point, they were able to put the gun in the affidavit, the typed affidavit. That draws serious question as to how long they waited to go in there for this dog. They didn't raise this really as an inevitability issue, and I don't know why the police are giving somebody's property to a random neighbor who says, hey, I can watch that dog. I mean, if it had been Mr. Curry's car, you wouldn't give it to a guy, oh, I know him, I'll hold on to his car. So the idea that we had to go in there and give this dog to create more danger for ourselves, to give it to someone we have no proof Mr. Curry knew, does not justify going into that bedroom.
I'm dying to know, but the record is silent. What kind of dog was it?
I don't know.
It was a barking dog.
Yes. Thank you, Your Honor.
Thank you. Thank you both for your arguments this morning. We'll take the matter under submission and issue a timely decision. And thank you both for allowing us to have this case presented here at the law school. Okay, thanks for being here this morning. For the students, it's my understanding that there'll be students flowing in and flowing out. So good morning again. We're still here at the University of Cincinnati College of Law. Thank you all for being here. The second case that we have is case number C240369, State of Ohio versus Brianna Benson. If attorneys can please identify themselves and their readiness to proceed. Okay, thank you. Good morning.
Please the court.
Good morning, Attorney Serkin. How are you?
Morning. This case is on its
Would you
second
like to
trip.
reserve some time?
Pardon?
Would you like to reserve some time?
Reserve 3 minutes.
Okay.
This case is on its second round to this court. Originally, the trial was had. It's a very, very sad and tragic incident. It started out as an evening of people entertaining themselves, and it ended up with two groups meeting up and having kind of a free-for-all in the early mornings of the date that this occurred. After the first incident had occurred, my client, Miss Benson, went back to took her sister and her friends back to their car on Plum Street, and along with another friend of Miss Benson, she was then going to head home. Found herself kind of in the twangs of the one-way streets in downtown Cincinnati, and ended up going back and repeating where she had gone, and went back up 7th Street, eventually trying to get back to either Interstate 71 or to Central Parkway to go to North Side. When she came down 7th Street, she came back and met up. There was the group that was involved with the free-for-all that occurred earlier at 7th and Walnut. One of the young ladies, and tragically the young lady who lost her life, start approaching the vehicle as they came down the street and screaming at the car. And apparently it was trying to stop the car because her keys had been lost in the fight that she had the keys to her car. So she still thought that might be in that car. She didn't recognize the car, I don't believe, but she recognized the people. And she went and she followed and went after the car, started pounding on it. The car swerved around another car, a Uber driver that was parked on 7th Street, went sort of up 6th Street. This young lady had approached the car. She now had left the car, but my client had started to back her car up towards like parallel parking in front of the Aronoff Center. This young lady came up to the side of the car again, coming from the sidewalk, was pounding on the hood and on the windshield. And what had happened was the car was turned this way as it came in. It had not made the complete kind of turn that you would do if you're making, you know, a parallel parking. And the young lady apparently was positioned on the side of the car where her left leg was behind the wheel, like the fender. And when she started to do that, my young lady started to go forward. And then the big dispute that came up is whether she deliberately turned the wheel to the right, which then, when she moved forward, it sucked the young lady down because it went down and the car went over her
So it
body.
comes down to whether she intended to hit.
And she proceeded forward.
So
Very
Attorney
serious
Serkin,
question.
it really comes, the issue is whether she intended to hit. And so
That's
the
right.
wheel, the position of the wheel
It
is
was
then
very
central to
serious,
that
was
question.
whether there was an intent to cause any kind of injury to anybody in, you know, she was charged with murder. She was charged with murder, committing a felonious assault. We believe, and I believe it was actually a reckless operation of the car. And it was really was, at most was a vehicular homicide, maybe a felony and a second-degree felony, which would have been 2 to 8 years.
So I guess the first question that I have, the state put on somebody that was an expert who testified that the wheels were, if you watch the video, you can see the wheels were purposely turned to the right. And then he went on to say that this demonstrated the intent. So he testified basically to the ultimate issue. This court held on appeal that that was improper.
Correct.
Okay. So if this case were retried, your expert also would not be able to make any sort of comment about intent, right?
But my expert would have been able to testify that the wheel appears to have moved because the vehicle camera that actually shows the best was the Uber driver. At the moment that this incident happened, the Uber driver was moving the vehicle forward. And this is what creates the illusion that the wheel was turned. That because of the movement of the Uber, he would have been able to testify to that. He may not have been able to testify as to the intent of the driver, but that makes a significant difference because that testimony and the nature of the way it came in that trial by the police expert who testified on an ultimate issue threw in there the fact that, you know, based upon his experience and others that watched this film or watched this video came to the same conclusion that it was intentional. The significant thing is, and what happened was, is that our expert, number one, counsel did not submit a report, and what he would have ultimately said was not proffered into the record.
I'm trying to understand though, because I feel like there were two different things that your expert either said or wanted to say. The one thing that I thought your expert was allowed to say at the trial was that when she backed up and she stopped, her wheels were already turned to the right.
Right.
So the jury they did hear that, right?
Right.
Okay. And what additional information did you think should have been presented?
That the reason it appears that the wheel would have, to someone else, might have appeared to be turned by the driver to the right was the fact that the video camera that was being used by the Uber driver, he was moving forward at the time. That's why you get a video expert, is to tell you what and to really analyze. He broke it down. He made all kinds of slowing it down, and he had captions with it, and it would have shown, and that became the key issue, is did she turn?
The trial judge in the post-conviction, Judge Branch, she said that the information that you wanted to present was already presented to the
But
jury.
it's not. I believe she's incorrect in that because he was unable to get to that point to talk about the Uber vehicle moving forward while the video was being taken, which made the appearance that the wheel was turned to the right. He did testify. I don't know if he got that far in the trial, that going over the body was like, as he did in his deposition, it's like your car going over a curb. It'll move with the curb, and that's what happened. And the then movement would have explained the appearance and why it appeared that the wheel was turned, that she turned the wheel, because it did turn as it was going over the body.
That's beyond something, you're arguing, that's beyond something that a jury could determine simply by watching the video.
I don't think they could have. Because I think that if they had that explanation, because there was nothing to refute what the officer said. I mean, the way the officer said it in his testimony, he not only spoke for himself, he talked about others in a profession and how he would see what ordinary people would not see. So he planted that in the mind of the jury. And I think it would have made a difference in the first case that you had that in the record, what the proffer would have been. And it would have been looked at a different way, because as it was, I mean, it looks horrible. That's why, again, you get a videographer. And I'm not so sure that he was unqualified to make the final, as to the intent, as to the police officer did, because Mr. John had testified at least 15 or 20 times in courtrooms. And although he never went through a certified course in reconstruction, he had testified and had worked with officers on many occasions on just this type of subject matter. And
Was
so,
his video compilation, was it actually shown to the jury?
some of it was.
And was it in evidence?
Pardon?
Was it in evidence? Did it go back to the jury room?
It went into, I mean, the videos, the Uber driver video went into evidence, and it did go back with the jury, but he didn't go back with the explanation that was given, that would have been given by Mr. Jane, however he pronounces his last name.
Did the video that went back with him contain his notes?
No, well, it contained up to the point, I believe, is an exhibit, but it didn't show, it wasn't all the exhibits that we attached. I think there were only 2 of the exhibits, and then there were 2 more that we attached to the transcript, when we did the deposition of.
That's after the fact.
And that's in that deposition record. It's in the
Post-conviction exhibits were, I guess they were labeled as post-conviction exhibits. Those were not presented at trial? Because there was a compilation, I think.
There was a compilation. There was A and B, but I think that we had exhibit C and D that were additional exhibits that were attached, which he had prepared for the trial, but were not introduced in the trial, but were introduced along with the deposition that was taken.
And did those C and D, did they include the information that the perspective from the Uber driver?
I believe they did. And in his testimony and his deposition, he says it.
Well, I'm sure his testimony says it, but it seems like C and D would have been available at trial, and they may have indicated.
But he wasn't allowed to test. He wasn't allowed to go on. And the question is that it's assumed by Judge Branch that he would not have been qualified as on the construction aspect, and I believe he may have been because they objected to that. He conceded that he was an expert. Whether he was an expert in just videography or whether he was an expert in both the reconstruction part or not, really is not discussed in the record.
I'm just trying to understand, just so that I understand the significance of his testimony and what the jury had and what you think they should have had. Because my understanding of what the state presented is that, and they harped on this in closing, they said, you can see the wheels turn to the right. This was intentional. That was their case. Your expert actually was able to testify that when she backed up, the wheels were already turned to the right. And then I believe, correct me if I'm wrong, defense counsel in closing argued they didn't turn to the right. You can see on the video, they were already turned to the right.
But that's not evidence. That's not evidence. It's his comment on it.
Well,
Nobody ever said,
video,
that nobody from the witness stand said that the wheel didn't turn, that it, didn't say that the wheel was not turned, other than the lawyer in closing argument. He said that in closing argument.
But I thought that your expert was able to get in before he was cut off, that when she backed up, the wheels were turned to the right.
He said that her wheels were turned to the right. That's right.
Okay.
But he doesn't get to say that, to balance what the police expert said that the reason it looks like it went to the right is because once it would start moving forward, she didn't have any opportunity to do anything with the wheels. The wheels on their own, it appears that the wheel is turning.
So that would be the explanation for the.
That was the
variance.
expert with it, right.
Okay.
And I believe he would have been qualified to at least get to that point. He may not have been able to talk about the intent, but once that was permitted about the intent, if you're going to give a fair trial. Now, I know there was no objection to that police officer giving that opinion, and I don't recall from the record whether in fact I think there was argument that they didn't comply with the 21-day rule. He just didn't object. He didn't object to it. And again, the jury, the last thing that they hear from the court is the argument you're going to hear is not evidence. It's only to persuade you. So that's unsupported. The conclusion that the lawyer comes to in closing argument isn't supported by any of the evidence that's in there other than, and again, the police officer makes the big deal that he looks at these with a different eye than the ordinary person would be. And I think the same thing happened along with Judge Branch in her findings on this, that what she looked and what she was looking for, she knew what we were asking and so on in that. And I don't know that, I think she was wrong. I think it was unreasonable in the conclusion that she came to.
How do you deal with the argument that there was overwhelming evidence otherwise that led to the determination that there was intent here?
I think that it could go any way. I think that again, it could have supported very well that it was reckless. It was, having not gone on and the potential of a risk. But I don't think that it's overwhelming that she deliberately ran this girl down. She was actually, in the battle that went on between the two young ladies at the time on Walnut Street earlier in the night, I think the one who came out victorious with it was my client. I mean, if you want to say who got the best of the fight or who delivered the most severe blows or whatever, so that I just don't believe that this young lady, and I don't think the evidence, if you look at it overall, I think it may support that she was reckless. She should have just gone on when she saw that group of people instead of stopping or whatever in that, but I don't think that it was intentional. And I think looking at the evidence as a whole, it's a terrible situation. It's a horrible outcome that would happen. I just do not believe it supports that she deliberately and intentionally went and took this girl down. If she was going to do that, she would have done it when, as Mr. John said in his deposition, when she was smacked from in front of the car, as she was coming down 7th Street. So I think that I do believe that had he been able to finish his testimony and the lawyer had put that into the record, that there's a problem, that there is, you can't say absolute. You can't absolutely determine, how you could say it's harmless, but it was a harmless error by letting the officer so positively testify in the manner that he did in the trial.
Thank you, Attorney Serkin. It sounds to me there's a phrase that keeps coming to my head, optical illusion. It seems to me that the videographer was there. You wanted that testimony in order to explain why what the eye is perceiving is different than what actually is happening.
And that's
understood.
He was so for him to have given that information. I think he was very strong with it, and he was very strong giving it his opinion that he ended up giving ultimately, believing that it was.
Thank you.
Not intended.
You're over your time, but thank you. Attorney Cummings, good morning. How are you?
Very good, thank you. Your Honors, I think that the trial court here followed this court's lead and its rationale in finding, in denying relief here, and I think that was the appropriate call. I think basically, as the trial court noted, the substance, the gist, the most important part of Mr. John's testimony was before the jury at the trial. I think he wanted to say ultimately that she didn't intend to strike Maddie, but that would not be admissible anyway.
Well, what I understand that he wanted, that the testimony that was sought was with regard to what the eye is perceiving on the video in comparison to what was actually occurring on the video.
I think that's one aspect that was different. I think maybe his explanation of how the perspective changes as the camera itself moves, being on a moving vehicle. I think that might be something that Mr. Serkin was referring to. But overall,
What was the gist? What was the gist that he got in? If he didn't get in that part about the optical illusion, it seems like you think he got in most of what he was supposed to get in.
well, the gist is that the car's wheels were already turned to the right when she backed up, and when she went forward again, the fact that it veered into Maddie wasn't a result. Now, he didn't say this, but that's the implication. It wasn't the result of an intentional act. He put before the jury that the wheels were turned to the right when she backed up, such that when she went forward again, it was already in play that it would go in that direction. That was put before the jury. What wasn't put before the jury was his opinion that it wasn't intentional. And there were three other things
What
that
wasn't put before the jury, I thought that Mr. Serkin argued, was the wheels, that apparently in the video, the wheels they look like they kind of go to the right a little. And this is what everybody was focusing on. This is what the state's expert was looking at. This is what the state argued. And so that testimony was cut out about the wheels kind of jerking to the right and the reason for it.
yes, that wasn't,
And then
Yeah.
isn't that pretty significant in the grand scheme of the case?
well, not really. And here's how the trial court identified what was missing. Judge Branch said there was three items she picked up on in the deposition that was not before the jury. The first one was that Miss Hart's foot was close to the front of the tire. And number two, in his opinion, the driver couldn't see where her feet were. And number three, the movement to the right wasn't caused by an intentional movement of the defendant driving into Maddie, but rather by the impact of the car with the foot or the body itself. Those were the things that the trial court noted that she gleaned from the deposition that was not put before the jury. So it really, the court can review the record and determine what it thinks was there and what wasn't there. But at the end of the day, the question is the same. Really, would this have made a difference? Because at the end of the day, you still have a videographer who's, granted, he's an expert in cameras and angles and all that goes with that. But at the end of the day, he's just another witness or an eyewitness that, is saying what he sees. And
Do you think
video
he would
wasn't
be
the
able to-
only,
Do you think he would be able to testify in a retrial as an expert?
as an expert videographer.
Okay.
Yeah.
So this could come in at a retrial, this testimony.
To the extent that he's an expert in videography, and I'm sure he could explain how camera perspectives change as objects move and this kind of a thing.
So there's that one little bit of extra information that might be in a new trial versus all of the evidence that was in the original trial, which includes the other witnesses and the police reconstructionist.
Correct, yes. And that's basically the state's point. That was this court's point, when it wrote the decision. There's just so much other evidence of intent or deliberateness in the record here. This case would not rise or fall as to the nuance that Mr. John may or may not be able to provide in a retrial.
And what is that other overwhelming evidence of intent that's in the record?
Well, there's countless, well, not countless, but multiple camera angles, multiple text messages, multiple social media posts. The chronicling of Ms. Benson's behavior for the whole night, which indicates that, she was not unfamiliar with the streets. She knew what she was doing. These were deliberate steps that she took.
How many eyewitnesses were there?
I would guess between 5 and 12, but
Including the people who were involved in the
yes,
ongoing skirmishes?
yes. And in addition to multiple camera angles. So this there was so much evidence here of what happened, not only among the witnesses, but also the cameras and the videos. As far as other evidence of her intent, that's been the point all along. You don't need the videographer's opinion as to moving camera angles and how that perspective affects the video. As this court found, the jury itself can watch the video and take into consideration what it sees. Anybody that has ever filmed their family or friends or pets knows how your perspective changes as you move a camera. I don't think this is beyond the jury's understanding in any case.
So do you
need
not,
him to
do
see
you,
that.
do you think that expert testimony, like suppose there were a retrial, expert testimony wouldn't be allowed at all to interpret the video? Is that what you're trying to say, that the jury could just watch
Well,
it?
it could be expert testimony from the police investigator and Mr. John could be admissible, and it could go, I guess, in some cases to the ultimate issue. But yet this court's already found this is not the case where that would be appropriate, because this is not the kind of case that you would want an expert telling the jury what they're seeing, because it's not beyond their province to figure it out on their own. So if there's a retrial in this case or in any case, the admission of the expert testimony will be limited to whether or not that expert's testimony can help the jury. And that's why we go back to the very nature of this case. The nature of this case determines this appeal. It determined the first appeal. This is such a incredibly fact-intensive case, and there's so many facts and factors and witnesses and cameras from which the jury can draw their conclusions from, that the opinion of an expert
Ultimately,
is
what's
not
at issue is that,
critical.
ultimately, what's at issue is that precise moment, is it not? And I think that's what Attorney Serkin is trying to get to, is that precise moment, what actually occurred in that precise moment.
At that precise moment, no witness will be able to testify at a retrial what the intent of the driver was. So that's not going to be admissible. Because
But if the jury were to believe that the wheel was not moved, wouldn't that change the outcome of the proceedings?
Evidently not, because multiple witnesses testified to that. Many witnesses and camera angles showed that the tire was already pointed right when she backed up. That was already in the record.
Well, there was conflicting, evidence on that regard. So if the jury were to believe that the wheel did not move, wouldn't that change the outcome?
I don't believe so.
I mean, the state's position is that little extra bit of extra information, it might not even register with the jury.
It's going to be another paragraph of testimony in thousands of pages where the jury's going to hear a bunch of witnesses talk about what the jury itself is seeing and what they're watching. This is not the kind of case where a videographer is going to make a difference in his opinion as to whether or not the wheel was straight or not, or they're going to be able to see that, as they were able to see that at the first trial. This is not a game changer. This is not the nature. The type of case this is not the type that the expert's testimony is going to be determinative. And I think that's what this court's point was in the first decision. That's what guided Judge Branch below. And once she read the record and heard the witnesses, she understood this court's point. This was a uniquely fact-intensive appeal that a jury can assimilate everything they saw and heard, and it was not beyond their ability to make the call. And again, the small amount of things he might be able to get in at a retrial that don't go to the ultimate issue will be minuscule compared to the overwhelming other evidence of intent that this court and the trial court below already has chronicled, demonstrates the culpability here. So it just wasn't a game changer. That's the bottom line. Unless this court has any further questions, that's basically the state's point here, as it was this court's point in the initial decision.
Thank you.
Thank you.
The overwhelming evidence showed that there was a battle between Brianna's sister and another young lady, not the young lady who ultimately got hit by the car. And it doesn't, I think that it is a game changer. I think it's the most important element. I think, Your Honor, Judge Zayas, you indicated it, is at that moment. What had occurred earlier this was a big sister coming downtown to get her sister and to protect her sister. She wasn't involved in the disagreement that went on between two other young ladies, one of which was her sister. That fight was over. That was done with. She came back. Her explanation was in her statement to the police. She got confused with the one-way streets. And you know, at Plum Street at one point, before now with all the construction, Plum Street does cut off and you can't go past the convention center. But as you get to the convention center, it swerves off. You have to go turn right and then go around in that. And if you're not going downtown every day, you could get confused with the one-way streets and, you know, and what happens to Plum Street as you're heading towards 6th Street. And I think it is a game changer. It's really significant. None of the other people would have the ability to go back and slow motion it and be able to interpret and take into consideration the movement of that Uber driver and him taking that picture. It creates an optical illusion.
An optical illusion for like less than 4 seconds, less than 3 seconds. He's going to,
Pardon?
it's like less than 3 or 4 seconds.
But if you highlight it in closing argument, it balances out. You got to consider that it would be isolated. You wouldn't have that testimony of that police officer. That police officer was insistent. I know it. That was the intent. And my colleagues saw it, and they said it was the intent. I mean, that's the key to it, is that testimony is so strong and it's unopposed. There's nobody that really can counter any of that because he was cut. And he even put it in the record. And I think the record, when it came up here, it wasn't completed because there was no proffer made. And that was unknown to the panel. And I think because I thought when reading the decision, that's my opinion, but I know the effects in trying cases, what little things make a difference. And that would have made a difference. I'm not saying that she wouldn't have been found guilty of anything. I believe it was a vehicular homicide, and it may have been a felony vehicular homicide. It was not a murder.
Attorney Serkin, what I hear you saying is that the narration of the police officer would have weighed strongly to the jury.
Absolutely.
Absent, something to contra that.
Absolutely. I mean, they made him into this expert and so on, and there was no objection to it, but he was very emphatic with it. And so I submit it to Your Honor. I believe that there is a probability that it could have affected the outcome. And I think this young lady is entitled to a new trial. Thank you.
Thank you. Thank you both for your arguments this morning. We'll take the matter into submission, issue a timely decision. Wish you both a wonderful afternoon, and thank you both for your willingness to come here and share of yourselves with the students this morning. Thank you. And so we have one more argument, but we're going to take a 15-minute recess. Good morning. So we're here on the third case, the last case that is scheduled to argue this morning. And this is case number C240363, Tasha Gibson versus Mercy Health of Southwest Ohio et al. If the attorneys can please identify themselves and their readiness to proceed. Thank you. Thank you.
May it please the court, counsel, Your Honors, I'd appreciate reserving 3 minutes of time for rebuttal.
Right.
The narrow issue before you this morning is whether the trial judge acted arbitrarily and unreasonably in striking a properly drafted treating physician's affidavit as untimely despite no apparent prejudice to the defendant or significant delay to the court. I think it's important that this court keep in mind that the sole basis of the trial court's stated decision to grant Mercy Health's motion for summary judgment was the fact that plaintiff's treating affidavit and supporting materials were filed a mere 2 days after the deadline contained in the court's recorded entry. Also, within the time period which the trial judge gave informally at an open hearing, it's never been refuted to this date. And in fact, you've got a transcript where the judge was given multiple opportunities to state otherwise. Considered in a vacuum.
So just a question on that one. So this was a hearing that was not transcribed, but then at a later hearing, you mentioned this date and nobody refuted it.
That's exactly right, Your Honor. There was a pretrial earlier in the month. At that time, we were still waiting for the supporting evidence, supporting affidavit. The entry that I actually submitted with a somewhat arbitrary date of May 15th was actually the entry that was signed off on by the judge, giving us that first extension. At that same pretrial, to your point, there was not a court reporter, there was not a transcript.
Okay, so it's not that you didn't order the transcript. There is no transcript.
There's no transcript. The only transcript came from the May 30th hearing on the actual motion for summary judgment, where we then referenced back the earlier pretrial, the judge's off-record statement that you get this in by the end of that week, which was May 17th, which is when we filed everything.
But the point is, you asked for that date.
I did.
And you got that date.
I did.
And it was on top of an extension of time.
This was the first extension to respond to the motion for summary judgment. The first request gave us until May 15th, which was the date that I chose, partly for my own trial calendar. Unrefuted, no objection from Mercy Health. But the point being, the stated reason that everyone was aware of was that Ms. Gibson had a new treating specialist that she had just seen in early March. We just got the records in late April, knowing that it took some time to get those materials and then subsequently supporting affidavit to respond to summary judgment. That was the stated purpose in the first motion that Counsel for Mercy, to his credit, signed off on. No issues.
Was it past the expert deadline?
The expert disclosure deadline was January 8th.
And so the defendant in this case wouldn't have had an opportunity necessarily to depose this person because they were a recently identified treating physician?
Depends on whether they had asked. They never asked to depose any of the other 4 treating experts that we had previously listed in our expert disclosures. Not only had we listed, and there was multiple, I think there were 20 throughout the record, I think there were 20 listed treating doctors at different times. We had actually narrowed that list down to 4 potential experts that were specialists. Those were specifically listed in our disclosures that were timely filed, along with reserving the right to supplement if later treating physicians came to light. And in fact, defense included that same supplemental language in their disclosures, which they timely filed, I think, approximately a month
Right,
later.
but when they include that supplemental language, everybody's expectation is if you have an expert, you're going to disclose that person as soon as possible. And in particular, in regards to a motion for summary judgment, you would expect the other side would want to depose someone who is going to put an issue, the primary issue in the case, at the heart of their opinion.
In a vacuum, you're correct, but they hadn't up till that point with any of the other experts that we had specifically named. So it appears the intent was never to depose anyone that we intended to list as an expert or get an affidavit.
All right, I'm just trying to understand because their expert said that based on, I guess, review of antibodies or whatever, that your client did not get infected with COVID, right, while she was employed. And so then you had to counter it with an expert that would say otherwise. So did any of your prior doctors and experts, did they say anything about when she caught it?
I mean, their treating records are not in the record.
Okay.
I would be making assertions based on.
But it's a workers' comp appeal, right? You failed it within the workers' comp appeal because that opinion wasn't presented in the workers' comp administrative
That's right. Yeah, I mean,
It's not like a regular, it's like not a regular civil case. It's an appeal from an administrative action. And in that administrative action, the failure was because there was a failure of an opinion that the COVID was caused during the occupation. Yes?
2 points. One, it's a de novo determination when you go to court. But two, they could just decide one doctor is more persuasive than the other. It doesn't mean that there isn't medical evidence in the administrative claim file that doesn't support the claim. The hearing officer at multiple levels could just determine their doctor was more persuasive. But once you get into court, all bets are off and it's a brand new ballgame.
But the only thing that you had here was your new expert that was going to be able to counter their expert. None of your prior experts could counter what their expert said.
And there's nothing in the record that says that. I mean, we had listed prior experts. Their treating documents were all part of the claim file. We just chose to go with the specialist who treats at a post-COVID clinic at Ohio State, in large part because of his credentials, and he was the most recent one to see her.
So the judge, it sounds like when she was granting the motion to strike, she faulted you for, like, this case had been going on for years, and then you never got this opinion until right then.
I think it was a narrow, and I would submit it was a narrow determination as to the timing of everything. So she wants the clock to start when, well, Mercy Health.
4 years ago.
Mercy Health wants the clock to start when she developed COVID allegedly in September, October. The trial judge apparently wanted the clock to start when Ms. Gibson, not with us, part of her case, but filed her first case. That case was dismissed. We refiled in July of 23. So in our position would be really the clock starts when the summary judgment motion is filed, because at no point prior to that did Mercy Health ask to depose any doctors. Didn't seem like there were any issues up until our second request. Because remember, in April, I let them know she's got this new doc, here's the records, and by the way, I'm working on getting an affidavit. Within a matter of a week, I filed my first requested extension unopposed. Judge signs off it, agrees with the arbitrary date that I chose. By the time of our second requested extension, the only difference was, hey, Judge, we're dealing with a big conglomerate, Ohio State Medical Center. The affidavit's tied up in the legal department. We've even got, as part of my second extension, I even attached a my chart note that says exactly what I said. Hey, we're working with the doctor. We can't release this yet. You know, we'll get it as soon as we can. At that point, now, admittedly, I didn't exactly know what the time frame was. It turns out it was only another day because we actually got.
So were you involved in the first 41A?
I was not.
All right. So you don't know why that one resulted in the circumstance that the first appeal was dismissed?
Yeah, I know there was a motion to withdraw from counsel, and we took a fresh look when she came to us.
Okay. And did you find any cases where the enforcement of a deadline that was requested by the party was determined to be an abuse of discretion?
I think there were some 8th district cases, nothing out of the 1st district. Probably the closest case on point, and I believe Judge Krause, you actually authored it, and I think Judge Zayas concurred. That would have been the Riverside Drive case. I think that's distinguishable in a lot of ways. That one didn't have to do with treating providers. There was a question as to whether the initial expert report was in fact a report, and then they tried to supplement with what they probably should have submitted the first time that actually gave opinions on the standard of care. So I think that was a very different case. And plus there was no, as I understood that case, the motion for summary judgment was filed and then nothing happens for like 6 weeks. And then they try and file finally an expert report. But that case would have been under 26B7C, which pertains to expert reports, as opposed to B7D, which pertains to treating providers. And if you look at the civil rule, it appears to be a much lower standard as far as what treating providers can actually testify to.
They can submit their medical records and testify regarding their medical records. But when there is a dispositive issue like this that is in the nature of an expert opinion,
Correct.
You'd agree it would be helpful to have an expert report, right?
Correct, helpful for sure. And the drafters of the civil rules could have said you're required as treating providers to provide a separate expert report, or not even gone that far and said, hey, in your treatment documents, for us to let you testify as an expert, there has to be some statements of opinions, but that's not what the drafters put in those civil rules. They indicate matters, the specific wording is matters addressed in those treatment records. So presumably they can expound on that in a fair amount.
And how is the trial court's order, or case management order framed? Does it make any such exception for the purpose of an expert report, or does it say expert disclosure and reports by X date?
Yeah, the actual case management order indicates plaintiffs' experts and written reports are to be produced on this date, 1/8/24. It does not indicate anything separate for treating providers. So it seems like there is a potential conflict between the civil rules and the local rules, and you could argue that Hamilton County is requiring more than what the civil rules require.
And that civil rule requirement, you would say, is from 26B7D.
Correct. Yes, Your
And
Honor.
is that basically explicit in B7D, or is it in the remarks to the rule?
So B7D for healthcare providers, a witness who has provided medical or mental health care may testify as an expert and offer opinions as to matters addressed in the healthcare provider's records.
So that is that trumped by the local court saying you shall you shall issue a report?
I don't necessarily think there's a conflict. I mean, if you're going to call a separate expert that's not a treating provider, then you should follow the case management order that says that separate reports must be turned over by the deadline. We never retained any experts beyond treating providers. Therefore, we didn't necessarily now we did file a disclosure and we listed the doctors at the time that we anticipated calling, the 4 out of the 20 total. Obviously, she hadn't yet seen Dr. Friedberg, the specialist at that time, so we couldn't list him. But I don't think there's necessarily a conflict there if you're going to call treating providers, not retain separate experts. So we don't run into the same issues that you had in the Riverside Drive case where they hired experts. That wasn't a medical case, but.
Okay, thank you.
Thank you.
You have about 1 minute.
1 minute.
Unless I hold on. Yeah.
Yeah, unless there's other questions, I think I'll reserve the remainder of my time for rebuttal.
All right.
Thank you, Your Honor.
Good morning.
Thank you, Your Honor. So to answer a couple questions that were raised, and again, I agree with Mr. Woolham that this is a de novo trial in court, but administratively, Mr. Woolham's firm was not representing Ms. Gibson administratively, but I was present.
Right?
I'm sorry?
Also not on the first lawsuit.
Correct.
Okay.
Well, I'll get to that in a second. Administratively, yeah, I was present for both hearings administratively, and Ms. Gibson did not provide any evidence of causal. And at least in my opinion, that's the reason I believe the orders state that there is no causal presented. But again, we're up in court on de novo. But again, it's as the trial court said, this wasn't you missed the deadline by 2 days. This is you had 3.5 years to obtain evidence of a causal relationship, and you didn't do it in a timely manner. The other issue is, yes, the other attorney that was representing her administratively brought the first case. She subsequently withdrew. Mr. Woolham's firm, and Mr. Woolham, I apologize if I'm misstating this, but I believe they did make an appearance in that one, and 41A did. And then at that point.
So they're doing a do-over on an administrative appeal, which as a matter of they're allowed to do that on a 41A on an administrative appeal?
Yes, because.
Is there law on that?
Yes, workers' comp administrative appeal is a little different than like an unemployment. Unemployment, when you're going up on administrative appeal, it's an abuse of discretion. In workers' comp, when you're doing administrative appeal, it's 4123-512 appeal is the revised code section covering it. It's de novo. You're limited to the conditions addressed administratively. So if the industrial commission denies a request to additionally allow the claim for a a medial meniscus tear, that is the only medical condition that can be brought up in the court. So that part's, but the part that's de novo is the evidence you can present. You can present any evidence once you get in the trial court. It didn't have to be presented administratively. That part's de novo, but the trial court's limited to the medical condition addressed below. Here, there's no question. The medical condition addressed below was COVID and post-COVID syndrome. Same issues here.
So we presume that they failed on causation below, and they get a do-over on causation with the trial court.
Right. And then if it's a jury trial, you're not allowed to tell the jury what the industrial commission did. That would result in a mistrial.
So the judge was, when she was granting the motion to strike, she was talking about how long they had to get this expert on causation. How long from the filing of the second lawsuit until the motion to strike was granted?
Second lawsuit was filed on July 6th of 2023, July 6th of 2023. First one was dismissed July 13th of 2022. The second lawsuit was refiled July 13th was dismissed. July 6th of 2023 was when it was refiled. The motion to deny strike was May or June of 2024.
2024, okay.
I might be off.
But at that point, when the new one got filed, the trial court sets a case management order, and part of that is to produce an expert report, and you would think that the expert report would be geared toward that causation issue.
Correct. And the reason that I didn't depose any of the doctors is that, at least in my opinion, looking over the medical records from the 20-plus doctors that she treated with, was that I didn't believe any of the records provided causal, so I didn't want to depose them to allow them an opportunity to provide causal.
And so then there's this new doctor that's identified after you file your affidavit.
After we file a motion for summary judgment and affidavit, the new doctor is identified. And I want to go back to Mr. Woolham talked about Civil Rule 26B7D, and he talked about the first sentence, but not the second sentence. And I think that's the key here. The second sentence says, healthcare providers' records relevant to the case shall be provided to opposing counsel in lieu of an expert report in accordance with the time schedule established by the court.
So you would say that's like the report,
Right.
like those records should have been produced in lieu of an expert report, and that was well before these motion for summary judgment dates.
Right. The expert deadline for plaintiff was January 8th. The discovery cutoff was March 8th. Claimant saw her doctor on March 6th, so 2 days before the discovery cutoff. Claimant did not produce the records until April 29th, almost 8 weeks after she saw the doctor. Claimant did, I'm sorry, using claimant here instead of appellant. Ms. Gibson did not file anything with the court asking that they extend the discovery deadlines, that they extend the expert deadline. She didn't ask it. She knew on March 6th, I saw this new doctor.
So would it be your position that at that point, they're just trying to save their causation argument through this, what to you would be a surprise witness?
Yes. I mean, I do not accept the proposition that Dr. Friedman is a treating doctor. She saw him one time. She saw 20 other doctors. None of them could provide, obviously they couldn't provide causal because otherwise they would have presented that in response to the motion for summary judgment. She sees this new doctor well after the expert deadline, 2 days before the discovery cutoff. They don't produce that for 8 weeks because the discovery cutoff, she saw him on March 6th. They don't provide the medical records until April 29th. Now, I'm not alleging that Mr. Woolham was hiding the ball here. I've done plenty of cases with Mr. Woolham. I know he doesn't play that game. But in any event, 8 weeks to get me the records.
He wasn't hiding the ball. He was just trying to get it from not going out of bounds, really. Right? He was trying to somehow save
the case.
Yeah.
Somehow save the case.
Did you know, though, when he was asking for an extension of time to respond to your summary judgment motion, that he was attempting to get this affidavit to show causation?
Yes, because he provided me the records on I'm sorry. I filed the motion for summary judgment April 8th.
Mhm.
He sent me those records on April 29th and told me they're trying to get an affidavit,
So when he filed his first motion for extension of time,
May 2nd. So it's about 4 days later.
you didn't oppose that,
I didn't
knowing
oppose
that, knowing that he was trying to get this affidavit to oppose your motion.
Right.
Okay.
I did oppose the second one.
I know you opposed the second one, but then I want to ask you about this May 17th
Okay.
issue. I mean, this is not in the record. Was there some sort of understanding that he would have until May 17th to get this affidavit?
At the oral arguments on his request for the first extension, the court did throw out a bunch of different dates, and May 17th was one of the dates. However, the court then signed the entry submitted by plaintiff that said May 15th. Plaintiff did not go back to the court and say, hey, that's incorrect. We talked about May 17th. And the court only speaks through its records. And even if the court said at the hearing May 17th, which I concede it did, the court only speaks through its records under Paul versus PNC First District 2022 Ohio 672, that the court is free to change its mind. So whatever it says on the record is not final until that entry comes out. And when the entry came out and said May 15th, plaintiff at that point could have gone back to the court and asked them to.
But you would have been okay with May 17th because you acquiesced to it, right?
I would have been.
And so were you prejudiced here?
My expert opinion was already out there. My affidavit was already out there. This point, trial was coming up in a couple months.
But you're not prejudiced, right?
I would have deposed his doctor at that point if I had that prior to all this happening.
Understood, but at the time, you were fine at the last hearing, you're saying, with the May 17th date. So I'm trying to understand how your case was prejudiced by him submitting the affidavit, I think, May 16th.
I guess at a certain point, you could always say that a case is never prejudiced because you can always be given more time.
No, I'm not saying that. I'm saying that when you agree that you're fine with getting this affidavit by May 17th, how are you prejudiced by getting it on the 16th?
Well, we got it on the 17th.
Around the 17th.
17th. To be honest with you, I can't really say.
Okay.
Okay. But I think this again, this is whether or not the trial court abused its discretion. And the trial court said this isn't about 2 days. And in the transcript afterwards, after the court made the ruling and counsel, Mr. Woolham and the court continued talking about it, the court said, this isn't about 2 days. You've had almost 4 years to get your evidence in order.
But she was represented by other counsel who looks like they might have dropped the ball there.
But she was represented by this counsel as of at least July 13th of 2022 when they dismissed the first case, because this counsel's firm was representing her when the first case was dismissed. So they had a whole year before they even refiled it to go get more evidence, to go get the causal evidence. And then once they refiled it in July, they had until they knew that the summary judgment deadline was in April. So they had 9 months to get any evidence. At a certain point, the prejudice to my client is that basically we have now spent 3.5 years litigating a case where claimant has no evidence to support their allegation. At what point is it's enough? You've had plenty of time. Yes. A trial judge can, and appellate judge, Supreme
The
Court
heart
judge
of
can always
attorney-
make this different decision.
Counsel, the heart of Attorney Woolham's argument is that it's such a nominal difference, that it's a date that everyone was fine with anyway. It doesn't seem like there's any prejudice. So how is that an abuse of discretion? Putting aside the fact that the court speaks through its entry, how is that an abuse of discretion?
I don't think it was an abuse of discretion for the court to say, I've given you enough time. I'm not going to
I mean,
change it.
equally, you'd agree that if she had just said, oh, it's fine, we're just going to allow the report, then that wouldn't be an abuse of discretion either.
Correct.
It's just
So-
that
so I think-
at that point, the
sorry.
court is simply enforcing the deadline that was suggested.
Correct.
As to the 41A, do you know, how long does someone have to appeal from the industrial commission? Is it 30 days or 60 days? And then you get a do-over as a matter of course with the 41A, even though it's an administrative appeal?
So again, I understand the point you're making is that at this point, she's had 3.5 years. What's another 2 days going to matter? But again,
Didn't he also present some evidence with regard to the challenges in getting what was needed from this particular physician or from this expert? Wasn't that part of the record that he developed below?
well, Mr. Woolen represented to the court that he was having issues with legal at Ohio State getting the affidavit approved to be able to provide that to be able to submit it with his memorandum in opposition.
So, I mean, I understand that, either way, it's a challenge on the abuse of discretion, but, I mean, what would be your key argument as to why this was not an abuse of discretion?
I think the courts, as the first district has previously said, the courts. I'm sorry, I want to find the quote and turn the page. Trial courts have broad discretion in managing their own dockets, including their scheduling orders and enforcing those orders. I don't think this is an abuse of discretion. I think the judge's discretion could have gone either way. And either way, I don't think it rises to a level of an abuse of discretion. Or it could have said, it's 2 more days. I would have been up here. I don't think I would have had a leg to stand on abuse of discretion. She went my way. I don't believe the appellants have a leg to stand on abuse of discretion. It was really the court's discretion. You've had this much time. I'm going to give you one extension. I'm not going to give you another one. This is it. You knew the deadline. You had all this time to get it. You didn't get it.
But is it an abuse when everybody agrees that she did recognize that the 17th would be okay? Or are you just saying, well, no, because she subsequently filed a written order that said the 15th, so she might have changed her mind? I mean, is that the argument?
Yes.
Okay.
And that claimant basically waived that by not going back to the court and trying to get that changed.
Right.
Is prejudice an element of the abuse of discretion standard for this course review? Is prejudice an explicit component of that? Like whether or not there was prejudice?
No, I think it's basically, was her decision arbitrary and basically not grounded in any reason whatsoever would be an abuse of discretion. And I think that she clearly had a basis to make her decision. Again, she could have ruled either way, and I don't think it would have been an abuse of discretion. Whichever way she was going to rule, one of us was not going to like that decision. But it doesn't rise to being arbitrary or capricious or without any basis in fact to make the decision that she made.
You have about a minute left.
Okay, unless there's some other questions, I don't want to beat a dead horse, basically.
All right. Thank you.
Okay.
Just to confirm, I still have 4 minutes. Is that
You had reserved 3, I believe.
okay? I wanna
So
start-
back to my same question. Is prejudice a component of that abuse of discretion review for this court? Does it
So-
matter if there is prejudice or no prejudice below?
I think it's built in. I don't know that there's case law that says it that directly. But if you're talking about whether judge's decision to strike or allow in evidence is arbitrary, unreasonable, capricious, and a judge is supposed to exercise careful and cautious discretion, then I think necessarily a component of that is going to be prejudice, or lack thereof. And I think more than anything, that's my biggest concern or argument here is what changed other than 48 hours? I mean, the exact same reason for the initial unrebutted request, and in fact, and I don't, Mr. Moskowitz is courteous throughout. He's courteous this morning. That's the case all the time. So I'm not at all surprised that, that he didn't object to my extension. But again, I didn't hide the ball. I told him exactly what we were doing, why we were doing it, and it's just taking longer. And not in hindsight, we're literally talking about 48 hours is what it comes down to.
Mr. Moskowitz, he ended his argument with the trial court's ability to manage their own docket. And here we're talking about a motion, right? So wouldn't that apply to any motion that would be denied, and then on abuse of discretion, then there would never be abuse of discretion?
Well, out of context, sure, but again, I don't think you can consider all this in a vacuum when you consider the fact that the judge stated, admittedly off record, but then not refuted on record, that we had until the 17th, and the fact that the court was well aware of what we were trying to do. I mean, when I asked for an extension, and remember that the initial summary judgment motion wasn't made because we didn't have an expert or expert report or a statement of causation. Their motion was based on their doctor's opinion that on the merits, we couldn't win our case.
So really, the heart of your argument is that although the entry had May 15th, that in actuality, it was understood that the 17th was fine, and that in essence, to a certain extent, it wasn't untimely.
It's part of the argument, but even beyond that, it was an abuse of discretion to not accept our supporting evidence that was admittedly filed 2 days after that date on that entry, in light of everything that everyone knew all along. The whole purpose of the initial extension in the first place, none of that changed. So given all of that information, all those facts, the timing of events, that was where the abuse of discretion. Sure, the fact that she said off record was part of that. I'm sorry.
What about his B7D argument, that second sentence? Like, you were basically noticed by both the civil rules and the court's order that you needed to produce an expert report by X date or produce treating physician records by X date in lieu of a report. And you were well past that report. And the reason they filed their motion for summary judgment is their determination was, oh, there's no opinion on causation, which was the same issue below.
Well, I take issue with that last statement, Your Honor, because that wasn't the basis. Their basis was their doctor's affidavit that said, I've looked at the diagnostic tests, and based on that, you can't prove that she had COVID.
I mean, obviously, he can't say that, but he needs an expert that's going to say that. And he identified that expert consistent with the
Correct. He
expert
did,
deadlines.
absolutely.
Right. So he did that because he knew that you didn't have the opportunity, or based on his review, that there was nothing you could oppose with either
Sure.
expert report or treating.
It was a calculated decision to basically force us to go get an affidavit. I mean, this doesn't happen in every case. A lot of times, okay, you got your doctor, we got our doctor, and eventually we go to trial. The only reason this became an issue is because they filed their motion for summary judgment, which essentially he dared us to go get an affidavit from one of the treating doctors that we had previously listed, or it just so happened she saw a specialist that was more qualified on COVID and post-COVID than any of the other treating doctors that she had previously seen. Now, would we have preferred that happened 4 months prior? Sure. But
Your response causes me concern because it goes back to what the trial court stated of all the time that you had in order to present this. And your response is basically saying the summary judgment was the catalyst for you to present this, as opposed to frustration or difficulty in being able to present it earlier.
well, the civil rules didn't require that we present anything other than what we had presented, which was the treating doctors, the list of providers, and who we anticipated to call as experts.
You're going to prove causation
With
without the new person. I mean, but your prior doctors, apparently there was no.
Was it fortuitous that she saw a post-COVID doctor in that time period? Sure. If she hadn't, then we would have been forced to get an affidavit from one of her other treating doctors. We saw the opportunity. Dr. Friedberg, again, his credentials were better than anyone else she had seen in that particular, for those conditions. And I know I'm running out of time, but I wanted to address Judge Nestor's question. So the civil rule, Part D, talks about presenting or giving relevant records in lieu of an expert report in accordance with the time schedule established by the court. we did it, we presented everything, we gave them everything that we had at the time of the disclosures. But the rules also allow for supplementation. In fact, not only allow for it, but require it. If you look at 26E, supplementation of responses, we're actually required and allowed to supplement the identity of each person expected to be called as an expert witness at trial in the subject matter. So the rules allow supplementation later on. It's not like we're locked in. If we find out there's other treating providers or other potential experts, the rules allow us to supplement those. And that's exactly.
Doesn't that theoretically allow a supplementation like all the way, like discovery had passed, right?
Discovery had passed, that's right.
So like you would be supplementing expert testimony after discovery and after the expert deadline, and theoretically, like in the 2 months before trial. That seems fundamentally unfair.
Well, I think most local rules, and I can't say I know Hamilton County specifically on that account, but usually there's a local rule that says you can't call any witnesses that haven't been disclosed more than 30 days before trial. So I think there's the discovery cutoff, but then there's what's required leading up to trial. And a lot of times there's time in between those dates.
Thank you both for your arguments this morning.
Thank you.
Take the matter under submission, issue a timely decision. And we wish you all a great afternoon. Are you staying for the Q&A with the students, or are you? Okay, you don't have to. And so that concludes the proceedings for today.